Hello everyone, good evening. Welcome to the GAPI webinar about estate planning and asset protection strategies for physicians. This event is hosted by GAPI President Uma Maheshwari Jonnalagadda. GAPI is a non-profit organization and this is an educational webinar, and attendees should consult their own advisors and attorneys for any advice. And this meeting is being recorded. Physicians or non-physicians, we all need some sort of estate planning. During COVID, I realized that our profession as a physician, how fragile life can be. Our beloved former API president, Dr. Ajay Loda, passed away after battling COVID-19. Estate planning rules change every year, and the information can be overwhelming and sometimes hard to understand when we speak to the attorneys. Also, as a physician, we are at a high risk of getting sued from creditors. Now, what are the steps for estate planning and how to best protect our assets? To simply this, we have Syed Nishat with us. Syed is a fiduciary financial advisor and partner at the Wall Street Alliance Group. Syed, his articles and interviews about asset protection and common financial mistakes by physicians are published in MedPage Today and Medscape. He's regularly quoted and interviewed in media outlets like Forbes, Kevin MT, US News, Investment News, and Yahoo Finance. We would like to make it more interactive session, not a long, boring presentation. I will ask questions and Syed will answer. You can ask questions as well in the chat box, and we'll try to answer them. So please use the chat box. I happened to hear Syed speaking at Alabama API governing body meeting a few months ago. His speech is very informative, and at the time I thought I should invite Syed to GAPI. So Syed, thank you for coming. First question I'll ask you, can you please explain what does it mean when you speak about estate planning and what are the components? At what age physicians should think about estate planning?
Yeah, thank you, first of all, Dr. Jonnalagadda, to invite me to this informative webinar. And we really appreciate what you do as a physician for the community and what you're doing for the GAPI chapters. Estate planning is extremely important for physicians. It's one of the most important but most neglected aspect of financial planning. One of my best clients, just to give you an idea, I've been doing this financial planning for almost 25 years. My best client during COVID in Texas passed away battling COVID. There's no way I can imagine his loss or having a disclosure, but having a proper financial planning and estate planning for the family, allow the family to focus on his health during this tough time and focus on other stuff while the estate planning was easy for the family to lessen the burden. Just to give an idea, if this client who passed away didn't have a simple basic will, simple basic trust in Texas, something as simple as the custody of the children would have been taken by the US government. So that's why it's very important, physician, they're in high risk profession to get the estate planning done as soon as possible. Now, a lot of people ask the question, at what age should I do the estate planning? I'm 43. A lot of people think, I was talking to Mike a few days ago about estate planning. She said, we'll do it when I'm 63. I think it's a mistake because what happened, age does not matter. What matters is that how much is your net worth and what do you have? Do you have retirement account? Do you have house, other assets you have? So it depends on that. So it's very important. That's why to sit down with estate planning attorney to get at least the basic will and trust for the estate planning done. Now, a lot of physicians get kind of confused about what does estate planning means. So what I try to do for you in today's presentation for the GAPI people, the GAPI physicians, to simplify it, very simple. So mainly there are three components when we talk about estate planning. One is called a will. In India, we have a will as well. Same way in America, we do have a will. All will does, if you just pass away, it just outline your wishes, what will happen to your property, who gets what. That's basically what it calls will. And who will take the custody of the children. It's a simple document. You can just write it and notarize it, and that's it. Number two major important of the estate planning is called living will. Living will consists of two important segments. One is called health proxy. You are a family physician. You probably know health proxy means if you are sick, who will make a decision for your health. That's called health proxy. Power of attorney means like if you are like my client who was passed away, who was very sick. When I remember that they put a tube at the time COVID, we didn't know what the treatment was. Like, all this medicine didn't came in. That was 2018, 19. So when they put the tube in him, he was unable to talk. But the wife, she had the power of attorney. She was able to call me, and we were able to take major decisions. So that's why it's extremely important to have a power of attorney as well. It works while you are sick but alive. And third part is living trust. So the issue people face, everyone thinks a will is enough. I don't need to do anything else. But think logically, Dr. Jonnalagadda, that if I, let's say, pass away, and my wife also pass away, it's not like tomorrow Manhattan, where I live in, the state county will come in and say, hey, here all your property. It doesn't work this way. Someone take the copy of my will, death certificate, and send it to the county I live in. They have to authenticate it and then release the money. It takes time. It is called probate. North south side where I am, New York, New Jersey, the probate is getting easy. But where at the south, like Georgia or Texas, the probate takes time. It takes about 3 months. You can avoid all of it by creating a revocable trust as well. And revocable trust is a private document. It's not a public document, so no court, nothing whatsoever. So just to simplify it, three components of estate planning: will, just get it done. Number two, living will means health proxy, power of attorney. And the third thing is a revocable trust. If your net worth is more than just a retirement account and a house, if you have multiple properties, or if you have some other brokerage account, to avoid probate, get a living trust as well.
So you spoke about the trust. What is the difference between revocable and irrevocable trust? And if you have a trust, you still need a will as well.
Yeah, it's a very good question. A lot of people, when I talk to the physician, somehow they got the idea we should do irrevocable trust, not revocable, because it gives you the asset protection. To get started, our recommendation is do revocable. Revocable means it's revoked. You can change it anytime. Irrevocable means once you make it, you cannot change anything. That's called irrevocable. So at the beginning stage, for all physicians who haven't done anything, our highly recommendation, get just a revocable trust. So avoid all the probate. If your net worth is substantial, I'm just saying, then, and if you want to give it to your children as a gift, the only way to do it is irrevocable trust to gift it. Irrevocable trust, when you gift it, the assets are protected from lawsuit, and it's gifting as well. So that's called irrevocable. You cannot change it. And the second part of the question, if you have a trust, do we still need a will? We do, because once you create a trust, Dr. Jonnalagadda, we have to fund it as well. What I mean by funding, the house, the brokerage account needs to be moved, but not everything cannot be moved under the name of the trust. For example, your jewelry, if you have it, you cannot put it under the name of the trust. It needs to be somewhere in the locker. So your car, that cannot be under the name of the trust. So that's why you have to have a will as well. It's called pour over will, meaning those are not under the name of the trust. The will takes care of it. So you need to have both as well.
What are the common mistakes physicians make when they create will and trust?
Yeah, so three major mistakes we see when they create will and trust. Number one, when they create a will, or the trust, they say, if anything, let's say, happens to me or to my family, they said give it under the name of the children outright. For example, I have two sons, Noah and Ayan. If me and my wife pass away, if I just say give it to my two kids, think logically, at one point they will grow older, they're going to get married, they inherit the money under their name, they get into divorce after getting married or lawsuit, all the assets are gone. So we recommend giving the money through the trust. The benefit of giving the money to the trust is if the children get into a marriage, get into a divorce, all the assets are protected. Again, don't give it directly under the name of the children, give it through the trust. Number two, a lot of time we see people make mistakes once they create a trust, they don't fund it. What I mean by fund it, like you have created all this, let's say I'm giving you as an example, Jonnalagadda Family Trust. You created it, but you haven't moved your house under the name of the trust. You haven't moved the beneficiary of the retirement account under the name of the trust. If you don't do it, it's just a fancy paperwork collecting trust. It will go to the probate anyway. So make sure you fund it as well. And third thing is make sure the latest provisions are there into the trust as well. What I mean that a lot of times physicians move all the time from one state to another state. If you move, let's say from Georgia to New York, I'm giving example, New York have their own statute, Georgia have their own statute. Make sure you incorporate the latest statute as well, update it every 5 years. So these are the common three mistakes we see when people create their estate planning.
So after you created the trust, how does the titling of the assets work?
Yeah, so titling means that all you have to do is the deed of the house. You just give it to the attorney. The attorney just send it, and they just move it under the name of the revocable trust. House will be just moved under the revocable trust as well. So there is no tax consequences, nothing whatsoever. It takes about a couple of months to move everything. The life insurance beneficiary should be a revocable trust. So what usually happen, we as a financial advisor or you with your financial advisor sit down with the attorney, they go through all the assets and they just send the county or the account you are owning the assets to change the title. That's it. It's a very simple process.
Some of our GAPI physicians are non-citizens, US citizens. Do they have to worry about special provisions in estate planning?
Yeah, a lot of physicians are actually non-US citizen. Those are like kind of the visa. They come in H1 visa or a J1 visa a lot. So, the one problems we have it when we create the estate planning, if husband and wife, husband passed away or wife passed away with husband, vice versa, if you're US citizen, all the assets are transferred unlimited, no taxes. That is not true for non-US citizen. So there's only up to a limit husband and wife can transfer each other. So unfortunately, that's the problem. So if you're a non-US citizen, speak to your attorney about Q dot provision. It's called qualified domestic trust. Q dot provisions allows you, if you're a non-US citizen, to transfer the marital deduction, the marital estate under each other's spouse without to worry about paying any gift tax.
If anyone have a child with special need, is there some consideration when you do the estate planning?
Yeah, I think this is very important. A lot of physicians don't know about this, that if you have a child with special need like autism or child with physical or mental disability, the child qualifies for government benefits, but the government benefits goes away if child have assets more than $2,000 under the child with special needs name. But there are few steps you can take to make sure that the government benefits prevail. And for example, rather giving money under the child's name, you can create something called special need trust. It's like a trust created for the child who has mental challenges or physical challenges. And under the name of a special need trust, you can transfer money and it doesn't count as an assets. Also states, for example, Georgia and a lot of other states allowing something called ABLE account. ABLE accounts, you can actually contribute and up to $100,000 and that money doesn't count towards the assets for the child as well. So again, if you have child with special need, it is extremely important that speak to your attorney and financial advisor about special need trust. Make sure nothing more than $2,000 under the child's name.
And how often we had to update the will and trust? You already said every 5 years. Is that right?
Yeah, usually every 5 years is a kind of a good time frame to just take a look to make sure, number one, has your situation changed? Have you moved to a different state? Did the child become older? Or if the latest statute changes or not. But typically 5 years is the time to just have a look back and see if any update needs to be done.
How much it cost to create a basic will and a trust?
Yeah, a lot of physicians are kind of the reason they don't want to do will and trust because they think it's very expensive. It's not the case. Just to give you an idea, if you just want to do the basic will, health proxy, power of attorney, a typical attorney we use, they charge about $800 only, just power of attorney, will, and health proxy. If you want to create a revocable trust, that costs a little bit money. That's about another $2,500. So altogether, between $300 to $3,500 will revocable trust, health proxy, and power of attorney are being taken care of. So if you haven't done it, that's the first step. But then if you want to do advanced planning like irrevocable trust, gifting, those add up as a cost. But just a basic will and trust, like you mentioned, between $3,000 to $3,500 is good enough to get started.
Let's, before we go to the next topic, that is estate tax, I have one question for you from the audience, Dr. Gangasani. He asked, can you explain more about revocable versus irrevocable trust?
Yeah, so revocable trust is by nature, by name is revocable. You can alter it, change it anytime after you create it and you fund it, such as beneficiary, any provision you can think of. Irrevocable trust, on the other hand, once you have created, you cannot alter the beneficiaries without their authorization, and it is much, much complicated, and sometimes court order is needed as well. So a good candidate for irrevocable trust will be if your net worth is more than, I would say, about 22 million. Think about gifting. Irrevocable trust is a good way to start sheltering money away. Revocable trust is a basic state planning for probate process. Usually we see people high net worth have both revocable trust and irrevocable trust, but if your net worth is, I would say, below 10 million, we recommend just stay with revocable trust and that's it.
I have another question for you. Do you have to do tax filing for ILET?
Yeah, so ILED is for tax purpose. It is a disregarded entity. What I mean by that, there's no tax filing for the ILED. ILED means irrevocable trust for life insurance. It's an irrevocable life insurance trust. That's what ILED stands for. One thing to just keep in mind, there's no income tax filing there, but there might be some gift tax filing. What I mean by that, like let's say, for example, you have some cash value like variable universal life, or whole life, and you transfer it. ILET usually have a separate tax ID number. Once you actually file it or gift it or transfer it through the ILET, you're transferring some cash value at that time. So some crummy letters needed at that time, gift tax filing needed if the amount is more than the gift tax limit, which is around close to $17,000 per year. If you go over that, gift tax filing needed, crummy letter needed, but there's no income tax filing needed for the ILETs.
Thank you. What is the estate tax or death tax? How does it work?
Yeah, so in America, unfortunately, there's something income tax, there's something called death tax. Death tax means after husband and wife both passed away. As of right now, anything more than 24 million, we have to worry about paying almost close to 40% state tax for any net worth more than $24 million. One thing to understand that is right now is 24 million, but in year 2025, which is 3 years from now, that's coming down to only about $12 million husband-wife together. So for example, if your net worth is 20 million, right now, if you pass away, there's none. But after the year 2025, if your net worth is 20 million, you passed away, anything more than 12 million, like $8 million, you have to worry about paying 40% tax. So I think it's very important that do some sort of planning for the state tax that's about to change.
Is there any estate tax rule change that we must worry about? That's
Yeah,
the one
so
you just said.
Just the one I just mentioned, that this is something that we do have to worry about, that the limit is going down if your net worth is more than 24 million. Right now, the net worth up to 24 million, there's no taxes, but it's coming down to $12 million ballpark.
For those who are at high net worth, what are the strategies to lower your estate taxes?
Yeah, there are a few strategies. I'm not going to go all of it, but just to give you an idea, one thing, remember someone, I think one of the physician, Dr. Srinini, asked that irrevocable trust, can you explain? So one option could be if your net worth is more than $24 million or close to the vicinity of 20 million, before the law change, you can gift it now through an irrevocable trust. Number two, every year you can gift about $16,000 to child, $32,000. There's no gift taxes due. The money is out of your state. Number three, if you have a life insurance, move it to the life insurance trust. Once you move it to the life insurance trust, the money is out of your state. And if you're charity minded, like for example, if you want to give a lot of money to GAPI, one option could be that create some sort of a charitable trust, which I'm not going to cover too much today, but just to let you know, you can gift a lot of money into charitable lead trust. You can make your children as a trustee, and a lot of advanced planning you can do as well. But depending on your net worth, either or combination of all of it could be used to lower your state taxes.
Can you elaborate SLAT, the Spouse Lifetime Access Trust?
Yeah, one of the physicians a lot of times ask that, hey, by the way, I want to gift it, but I don't want to lose control. Do you have some option? Like one of my clients were saying that net worth was more than 24 million. The client wanted to gift, but she doesn't want to lose control. What if the children kick her out of the house? What are the options for that? So we sat down with the client, with our attorney, and we spoke about spousal lifetime access trust. In a lifetime access trust, you can gift same $22 million out of your state, but the benefit is as long as one of the spouse alive, the spouse can take the money out and give it to the other spouse. So in this way, you have control over it. So it's called lifetime spousal lifetime access trust, and irrevocable trust, but you have better control if you want to gift it, but maintain some control over it.
How much does it cost for this trust setup for estate taxes?
Yeah, so we're talking about around close to $3,500. Remember, for the basic will and trust, $3,000 to $3,500. This one is not cheap; it is expensive. A SLAT typically costs about $5,000 on top of the basic will and trust done. So, but it is worth it if your net worth is more than 20 million to spend some money to get this done.
I have a question for you. Please, by Dr. H. Patel. Please explain pros and cons of BDIT versus SLAT.
Yeah.
Who can use them?
Yeah. So we haven't used the BDIT trust that much, at all. So the defective grantor irrevocable trust versus SLAT. SLAT are people who are marital spouse and have good understanding, and they want to have control over it. That's what the ideal candidate for SLAT. BDIT, we are hearing about this, the effective grantor trust, we are hearing about it, but due to inflexibility, we are not using it right now. All we are suggesting right now is to go for plain vanilla irrevocable trust or SLAT. Stick with it. The BDIT is, or IGIT, that these are the trust advanced planning, we see it, we're not using it right now.
Yeah, thank you. The next topic will be the asset protection. And why is asset protection important for physicians?
Yeah, asset protection is extremely important for physician. Just to give you an idea, according to, there was a statistic done by American Medical Association, 60% of physicians over the age of 55 get lawsuit at least once, and this is statistic quite higher for certain profession like OBGYN. So we don't have to really worry about spending too much money for asset protection. A lot of physicians think that asset protection is very expensive. Like depending on the state you live in, like Florida, they allow joint tenants in entirety. As long as husband, wife, they're alive, joint tenants in entirety will give you asset protection as well. If you have a physician spouse, other spouse is non-physician, as long as both of you have a good understanding, the other spouse who's non-physician give assets to the spouse, create two revocable trusts in this way. So in this way, if a lawsuit happens, the assets are protected. Another biggest mistakes we see is physician own properties under their own name, rental properties. Is one of the biggest mistakes you can make, because what if a tenant sues you? So the best thing would be you can create an LLC or FLP, family limited partnership. Doesn't cost that much. If a tenant sues you, the assets are protected. And again, 401k, cash balance plan, IRA account, that has elements of asset protection. But once you've done all of it, what I'm saying, and still you have want to do advanced asset protection, you can think about, like, as I said, SLAT. You can also do asset protection trust, like Georgia has domestic asset protection trust. Nevada asset protection trust, we will cover a little bit, and that give you the peace of mind and strong asset protection that you may need.
Is the primary house protected everywhere?
No, it's a misconception people have it. There's only a few states that give unlimited asset protection for primary house. Florida, Texas, they are the one. Even Georgia, not unlimited asset protection for a primary house. New York, where I live in, not unlimited asset protection. So depending on, if you have a lot of mortgage, most likely you should be fine. And very rare it happen that if you have an arbitration, someone actually go after your house. But still, if house is the biggest expense you have it, biggest investment you have it, it may be a prudent time to sit down, depending on your state you live in, and talk about some sort of asset protection for the primary house if you have put a lot of money into it.
What are some of the strategies of asset protection for physicians?
Yeah, so one of the strategies, beside the basic strategies I outlined here, one strategy is for physician who has like a lot of assets. Speak to your financial advisor or your attorney about Nevada Asset Protection Trust or Delaware Asset Protection Trust. People must have heard about it. It is very advanced level. The way the Nevada Asset Protection works is a irrevocable trust, but the assets are part of your state. You're not gifting anything. You need to have a trustee on the state you get in. For example, Nevada, you have to have a Nevada trustee. Delaware, you have to have a Delaware trustee to administer everything. But once you put the money into the Nevada Asset Protection Trust or Delaware Asset Protection Trust, typically after 3 years, the assets are protected. That's what it says. It's very expensive. It's not cheap. Again, those are only for high net worth physician and only for physician who are high risk profession. And they are inclined to do offshore account rather doing those. Think about Nevada Asset Protection Trust. You put the money into it. It costs about $6,000 to set it up. But you also have to pay a Nevada administrator to maintain it as well, which is about $2,000 per year. So again, high risk profession only, high net worth only. You can think about advanced strategy for Nevada Asset Protection or Delaware Asset Protection Trust.
I have a question for you. What are your thoughts on a DST, Delaware Stat Trust, and using it to acquire real estate?
Yeah, so DST, you can, but the question is that is it really necessary? The whole idea is for asset protection. That's basically the question. But as I mentioned, it's not cheap. It is, I yet to see a physician charge less than $6,000. Is it worth it? That's the question. Remember, Georgia, I'm hoping that whoever is asking this question live in Georgia. So Georgia have their Georgia Domestic Asset Protection Trust. It's called DAPT. It is not as powerful as DST, which is called Delaware State Trust or Nevada State Trust, but it is simpler than that. You don't have to pay like an admin fee to someone to administer it. You live in Georgia, you can have someone to create it, and it gives you the strong asset protection that you need. All physicians, I see get carried away or get scared by lawyers that a lawsuit is coming. But you need to understand that there's nothing called 100% asset protection anywhere, because if the government comes after you, no one can protect you. But what you do want to make sure that frivolous lawsuits are protected. So I think, in my opinion, unless your estates are very, very uh, big, your professions are very, very high risk, most of the time the malpractice enough to cover it. You should focus on getting the basic steps like LLCs, family limited partnership, all of this done. After that, still you have a huge net worth, then you can think about DST or Nevada and start thinking about dishing out so much money.
So what is the financial advisor role in estate planning and asset protection solutions for physician?
Yeah. So one thing very people do get confused. What's the role of a financial advisor? Very often we see people say, okay, is a financial advisor means investment. Investment is a portion of what a financial advisor do. But the true role of a fiduciary financial advisor is to take a look at your big picture, take a look at your estate planning, portfolio management, retirement planning, budgeting, and tax planning, and based off of that, create like a customized financial plan that is suitable for you. And make sure that when you speak to a financial advisor is a fiduciary, and they have the team of experts in-house, so they can take care of all your financial planning need under one umbrella very efficiently. A lot of times we see ad like a one financial advisor does everything. It is not possible. How can you have expertise on everything? So as long as you have the team of experts, they can sit down with you. And we believe that if a financial advisor is a fiduciary, can cost you so much, save you so much money that you end up spending into this complicated strategies. And that's why it's very important that when you speak with a financial advisor, make sure you ask it, are you a true fiduciary? Do you have the attorney, everyone in-house, so you can collaborate for me or the client and can take care of everything under one umbrella very efficiently?
Thank you, Nishant. You explained it very well and very informative. Thank you again for everyone to join this webinar. This video will be available online and will be emailed to everyone, those who joined this webinar. And good night, everyone.
Thank you very much, Dr. Jonnalagadda, for inviting us. And we're looking forward to long-term relationship with GAPI chapter. Thank you very much.
Thank you. Good night.
Good night.